expectancies.
I have just read out that part of the spy tapes when McCarthy is being told that he's the only one who can save us, who can save this country from its madness. Now, I'm going to go to the next part. I know that it uses at some point it uses language that is unpalatable, but I'm quoting the discussions of people. This is how they speak. Page 1524. Now this part, and I will invite the court to go through it at some point because I won't read of it. I'll start at line 92. It's Leonard McCarthy. Says, but I will call you when I'm up there again. At this stage, my flight is on Thursday. I did what you said I should, I must say. You did the right thing, says Bulelani. And Leonard McCarthy says, up until Friday, then I received a strong memorandum to say, charge and charge now. And Bulelani says, Friday. Yeah, no, this Friday. The team says we have been fucking around with this thing. And we are allowing ulterior considerations to play in. And it will become an impossibility later. We must take action and deal with it and finish and clear, as Jackie Silebi said. But that's another story. My lord and my lady, that bit, it's one of the key things that demonstrate that Leonard McCarthy was unlawfully discussing charging with somebody else who's not in the NPA. But there's another thing it tells us. It tells us what he thought of the advice that I said he was given. Charge now. Himself, just like Ngcuba.
But this deals with the timing of the timing of the charge of
yes,
charging the
it's the timing.
Yes.
It's the timing. It deals with the timing. And I will argue at the end is that there is no aspect of prosecution that must be decided with a politician. No matter how unimportant we think it is. I'm going to go where they talk about the indictment. Page 1528.
Sorry, Mr. Siatani, can I just ask, you're reading from this record, there is, on the right-hand side, there are comments. Who inserted these comments?
Well, that's why I don't read them, because they...
Yeah, I just wanted to know when we deal with the document as a whole.
Absolutely. The reason I... Remember, let me explain this document. I'm not a spy, but I think I understand how this works, is that when you have transcripts like this of people who've been recorded, right? You then on the side, because it forms no intelligence until it's really processed in their own cycle. And what you have on the side may be a comment about speculation about what they think. And the reason I'm not reading it to the court that much is because I do not want to burden this court with what I think either an intelligence operative or information analyst was writing, thinking what he was thinking or what she was thinking. So, McCarthy says, and by then Steinberg decided he wants to go home, and the kid wants to start his leave because his mother at the end of her life, and he wanted the last holiday with her. And one of deploy were on leave. And Trengov is on leave. And I sat drafting with one advocate, and we probably finished half of it now. Salmon must look at it. And Trengov said he wants, it's so important, he would like to see it before it goes in, before he must argue the damn thing, which is fair. So we will probe. No, Mr. Trengov didn't say that, and Mr. Trengov was not involved. They were talking about him. But I'm reading this portion because it talks about the indictment at some point. What did you say?
Is this the indictments or is it the affidavits in the
affidavit that they are drafting?
Yeah.
Then it says, can I get a draft? Can you deliver a draft at my place? Where are you now? In Joburg. Okay, I will be back. Leonard says, I thought you said you are starting your leave and you will be there. Yeah, but it's part of my leave. I was actually coming to Cape Town to see you, but no, it's fine. Leonard says, I will rather come myself. I don't want to take chances. No, because I will get there late tonight. Leonard says, no, I'll wait for you and call me when you are here, or I will see you first thing in the morning. Or you come to me, I don't know, but I don't want intermediaries here. Bulelani says, okay, you're right, you're absolutely right. Yeah, you know, Zuma will say we are conspiring against him. Can I ask, and the script has not changed yet. It's a question. I'm making one point here, that I said we must connect the right dots, not the wrong ones. We must connect the right dots about this pattern, that this is being discussed, whatever it is, unlawfully with someone who has no business in the prosecution of Mr. Zuma or anybody. But the next pages of this that I will invite the court to go through, and I want to summarize them because we will be here the whole week if I do. It's a lot of terrible things people are saying. Is that they will demonstrate to you that a president was involved in their discussions. A minister was involved in their discussions. That the timing of the prosecution had nothing to do with prosecutorial functions. That the timing, as you will see if you read the parts I have not read, is that precisely what the NPA has been told time and again by those who care to tell it. They do not have, and they are constitutionally prohibited from taking instructions about aspects of prosecutions and doing their work. So why is this important? Why is all of this important? It's important as I'll get to the cases now, because as we read these cases that deal with the permanent stay, it's a matter we've debated slightly that, well, a delay on its own and time is not enough for you to get a permanent stay. There must be extraordinary circumstances that exist. I want to invite this court to agree with me that when an organ of state as powerful as the NPA, now, in the future or in the past, because it will be us one day, when they discuss with political players about when you must be arrested and how you must be prejudiced by that, and they discuss it with people who have nothing to do with prosecution, our courts, which are the custodians of constitutionalism, must not tolerate it simply because we're dealing with a suspect who may have committed what we don't like. It's the point I am making. The point about this, is that the pattern of behavior is what distinguishes this almost 20-year-old case from the other cases, some of which a stay was granted after a delay of 3 years, like Mr. Phillips and others. But maybe let me just go, and I persist with the arguments we make there and those decisions. I also want to submit to this court that the court must go to those parts of our heads of arguments when we deal with criticism by our courts of the conduct of the NPA in this matter.
So let me just try and understand you on this point, because I think it's important. So are you suggesting that once we find that there was this discussion, we shouldn't look at the integrity of the investigation, whether it was tainted in any way?
No, there is no aspect that I'm inviting the court not to look at.
Yes.
That's the first thing.
So we still have to
You
interrogate
have to
the
look
integrity
at
of the
all
investigation.
of this and consider it. But here is the point I'm trying to make. I am saying, in your attempts to read and find how serious corruption is and all the points you must look at, you are the custodians of how organs of state must act. And whatever you find with all of those things, how serious corruption is, how insignificant the delay is, what is important, and I find that we submit is extraordinary, is what this court says about those who hold power of the state to prosecute others when they tell lies, or when they abuse, or when they connive with people who are outside the state. And it is the court's function to determine whether all the factors, my lord, you say you may want to consider, can ever justify an organ of state granting itself power to act as it wishes, and unconstitutionally and unlawfully, as we submit. Well, we have set out those facts. And my lord, I don't want to, I have gone through what we call in our heads the spy tapes. The reason I've not read all of it is exactly as I said. I've concentrated on those parts that really, really demonstrate to you that a discussion about an accused, an instruction was being taken from politicians. And this court must tell us how it views a national director of prosecutions taking instructions from an outsider and linking whatever they want to do to political outcomes. I know that our learned friends like saying, no, but Haram's dealt with that motive issue a long time ago. We're not suggesting, we're not dealing with motive. We're not dealing with that aspect. We're dealing with the fact that an organ of state acted unconstitutionally, violated its own policies, violated the act from which it derives its power, and lastly, violated the Constitution. And this court must tell us if, when it balances it with other things, that unconstitutional conduct can be condoned. Those parts, we insist with them, they are there. I want to go to invite this court, because what I'm saying here is not just the story that Mr. Zuma has told or is telling. I invite this court, without reading this affidavit of Mr. Hofmeyer, because that is the NPA. Mr. Hofmeyer wrote that as the NPA, condemning how they had behaved. I'm inviting this court again to read Mr. Mshe's statement itself, how the NPA had himself, this is the NPA, describe their own conduct. The fact that those who've come later for different motives don't like what he said, the fact that colleagues in the media, insurgent at the bar, call it what they call it, the fact of the matter is the institution itself at different times, those who have a conscience in it, have described their conduct as bad, indefensible, and unlawful themselves. It's not us only.
But, Mr. Sikakane, are we not going to be constrained in some of these criticisms by the findings of the SCA? For instance, in Mr. Hofmeyer, Mr. Mshe's, because they've made various findings in these particular issues. And I don't think we can find otherwise unless there is something that you convince us otherwise if they have found in a particular manner.
Well,
started the cases
yes,
dictates.
no,
So
I understand.
yes.
I understand. Let's get to that because it's a famous argument from our learned friends as well. Oh, the SCA has said ABCD. Ignore Hofmeyer. The SCA has said ABCD. Let me tell you this, my lady. That affidavit of Mr. Hofmeyer remains something the NPA stated on oath. The comments of the judges about his conduct, and we know he's still there, he's still around, and he's just been promoted, he acted well, so he's a man of integrity, he's there. His affidavit has not been found to be a lie. He has not written an affidavit countering that. I think the comments that I saw in the cases about it, our learned friends pick. They choose what it is that they think he's right by saying and where they think he's wrong. We say this court must consider an affidavit filed by the NPA in a matter on oath before it. And we do not have an affidavit disputing that from Mr. Hofmeyer. Mr. Hofmeyer, that's his affidavit. We say it's consistent with the statement of Mr. Mshe.
But Mr. Sikakane, I think what my sister alluded to is that when we look at the decision of the ACA, the Judge Nafsa criticized the affidavit by Mr. Hofmeyer, and that all appears on pages, I think, 230. And it concludes in paragraph 75 of that judgment. Mr. Hofmeyer was intent on imputing the decision to prosecute Mr. Zuma to Mr. McCarthy. He sought to dispel as untrue the statement made on behalf of the NPA in an affidavit in other litigation that Mshe had made the decision to prosecute. This was done notwithstanding that this court in Zuma had decided on the evidence placed before it that Mr. Mshe had taken the decision to prosecute Mr. Zuma. And then it goes on the criticisms of that. I think, if I understood my sister correctly, is we cannot ignore the findings of the Supreme Court of Appeal regarding that affidavit. Yes. So I think, is there a way that we should ignore this? What would then be your submission regarding the criticisms?
Yes. My lady, the SCA was never faced with the question you are faced with today.
Just on that point, Mr. Sikakane, the SCA has also spoken about the timing of charging. They say the motive is irrelevant.
Yeah, it has even said
Yes,
the motive
yes.
of prosecution is not a problem.
But if you go further than that, if you actually look at Mr. Mshe's statement, in his own statement, he makes a point that he could find nothing wrong with the investigative prosecution team. In other words, there was nothing wrong with the investigation itself. He makes that point. He makes it clear.
Yes.
Yeah.
But, my lord, I don't know whether I had finished the answer.
Yes.
But a lady had answered, is that they were first. Can I start with your question
Yes,
and complete it?
yeah.
They were not faced with the question you must determine. They made comments. They did not say that affidavit. I do not believe that affidavit must be ignored, what is said by this organization on oath must be ignored because the SCA had comments about Mr. Hofmeyer and what he was saying. It remains and they described their conduct on oath in court. The second thing is this, and I invite you to read more in the spy tapes because you will find members of the NPA discussing what to hide from a court. So it's not something I'm taking from nowhere. And I'm saying one of the issues you will have to deal with.
Is it really not a smoking gun that can be cleared by the trial court? That issue about the tapes?
Well, this is the answer I gave earlier then, my lord, is it depends on what you are dealing with. What I've presented to you is what I say are extraordinary violations of the Constitution. And there is nothing that can't be dealt with a trial court. But what I'm submitting to you is that violations of the Constitution in pursuit of even the ugliest criminal we hate cannot be condoned. And I'm saying it is extraordinary to violate a constitution. If you find, this is when I will lose this case. If you find, and you have to find this way to differ with me, is that all of the things that happen, the discussion with politicians in South Africa when I want to charge are fine. If you find that it's not unlawful when I'm prosecuting to do what we say Leonard McCarthy and Bulelani Nguga did, it's not against the spirit and provisions of our Constitution, I must lose this case. If you find that NPA from today and going forward in pursuit of someone who's accused, they can do what Leonard McCarthy was doing. They can take instructions from the DA and the ANC and everybody in order to time things to suit political players. You are free to take that decision. This court, I must lose this case if this court does not find that violation extraordinary. And I'm adding it because most of those cases tell us how difficult this is. I am saying this court, the three of you, sit here as probably the ultimate custodians of the Constitution. And I will gladly lose the matter if a court tells me that violations of the Constitution of this nature, unjustified, not in terms of Section 6636, which tells us how we can violate them if it's allowed. It's just done. I will gladly accept that I'm wrong. But I am saying it is extraordinary that people can violate a constitution the way they want because they are pursuing someone we dislike and they are pursuing someone they suspect. So it can be decided, my lord, in the trial court, but the court will have to go through what I'm submitting now. Disagree with me on what I've just told you now, and I'll gladly accept your verdict. Then we deal with the cases. I promised my learned friends I'll be done at 3, so that's why I'm rushing. I invite the court to look at all of the findings by Judge Msimang. There is no suggestion that Judge Msimang was wrong in stating the things I have stated. And he hadn't read, may his soul rest in peace, he hadn't even read the spy tapes. Even then, in 2006, he complained bitterly about the conduct of the NPA. Yes, I know Sergeant at the bar doesn't like Nicholson. Saying people say it wasn't, I'm saying I'm inviting this court. Read what he says. in relation to what you must find, you are determining what is before you, because it has never been before anybody. The questions you are dealing with have never been before any court, and you are free to determine it the way you wish without differing with the SCA. Now, what are the cases that should guide you, and what do they say? Where's my books? Let me start just briefly with the Bothma case. I'm going to briefly tell you what it was about without taking your time. This is in 2010. It's a constitutional court matter. In this case, Mr. Bothma instituted a private prosecution. Mrs. Bothma. It's Mrs. Bothma. Complaining that when she was 13 and 37 years had passed, she was raped or sexually abused by a Mr. Els, a family friend. I think it had been 39 years. And on 21 December, she instituted a private prosecution. She first appeared on the 5th of February, 2008. Just a year, I think, well, less than a year. Then it was remanded to 17 June 2008, the same year. Then, before it was heard, he brought a permanent stay application. And there are two questions that are important in this case for you to determine, because they raise issues about which we can get criticized in this matter. He says after 2-3 years, all the evidence is gone. This was 39 years ago. Now he's talking about the time when the offense was committed, not when the prosecution started. So basically, he's complaining, and he loses this case, because he's complaining that there has been a delay by the state of some 2 years or 3 years, because eventually it was set down in October 2009. He also complained that the offense occurred a long time ago, as if that makes any difference in terms of its nature. But of course, he was criticized because he talks about the time of his offense, not the time when the NPA started, when the prosecution started his case. And he loses, of course, because the court says he had to detail the trial prejudice that he complained about. He said people had died, the evidence was no longer there, he couldn't find his diary where he was on the day. And so, how different are we in this case? Well, I have it said to this court, first of all, you have to determine how long this has been. Secondly, you have to determine the fact that we've asked for documents, we don't have them, we don't have a full set up to today. You have to determine the fact that can we ever have a fair trial after such a lapse of time in a matter of this nature, and the type of evidence to be led in a matter of this nature. And lastly, because all of these cases tell you this is extraordinary, you've got to tell us much more. I don't want to harp on the point. There is something extraordinary about constitutional violation, I think. So our case, Mr. Zuma's case, is distinguishable from those cases for a number of reasons. The other one that our learned friend's case, and it's a famous case because judges make telling points, is the Sanderson case. And I know why our learned friends like this case. because it's part of the theory about Mr. Zuma. Mr. Zuma is they say he is the cause of the delay. And the Sanderson case at paragraph 33, I think talks about an accused who is the primary agent of the delay cannot come to court and complain that there has been a delay. It's like someone banning the court and saying, I'm coming for a permanent stay because the court is not available. And the court was right. In cases where the courts have said this, they were right. But I have said in our case, you cannot compare it with these cases if you look at the facts, you look at what has happened, you look at the violations, you look at who caused which delays. And there were many postponements in that case. I was going to read its passages, but I don't have to. Our learned friends, there is a case as well. It's the Fraser case that I referred to. Because we are lawyers, sometimes we pick cases that say what we want to say. But I think it's important to state all of these cases, including the ones that are not with us. This was a civil case for a start, Fraser case, unlike what we are dealing with here. The appellant was an awaiting trial prisoner who had been indicted on several counts related to racketeering and money laundering. So it's a different matter altogether, and he was charged in terms of poker. So a provisional restraint under Section 26 of poker was obtained against him, against his interest in a closed corporation and his other properties. So that's the nature of that case. But what does he do? This is the man they accuse later, as I will say, that he participated in wrongdoing that led to the delay. Because basically ABSA gets involved in this matter because it was one of Fraser's concurrent creditors who had obtained a default judgment against him. And they sought to intervene. Right, they lost, but then their case was dismissed. And then in the SCA, ABSA's appeal was upheld. Fraser approached the Court now to appeal against the SCA on the ground that its decision will result in unreasonable delay. And of course he lost, and he should have lost. Because as they said there, he had been involved himself in trying to conceal his property, his assets. So all of this case, I invite this court to go to the Phillips case versus the DPP, because in that one, it was granted. I invite this court, without wasting its time, to go to the Van Heerden case and look at it. I invite you to read the others and see that the golden thread that runs through them is that while these courts tell us that this is an extraordinary remedy, they tell us that when the fairness of the trial in terms of Section 35(3)(d) has been severely compromised or affected, you can't say you will not grant if that is demonstrated. The others tell us, as your ladyship was saying, the delay on its own is not enough, but show something else. And they tell us that, of course, because it's extraordinary, what exceptional circumstances exist? Now, I know that exceptional sounds like something spectacular must happen. I'm inviting this court to look at whether, if they find, as I say, an organ of state acting unconstitutionally, acting unlawfully in pursuit of a citizen, is not spectacular in a modern democracy, in a constitutional state. I'm inviting this court to tell me and us that it's not spectacular to act that way. And the submission I am making is that even if we are weak on every point, even if Mr. Zuma postponed all the matters himself in the past 15 years because he's a Stalinist, it is exceptional. It is exceptional that constitutional violations happen by an organ of state whose power is one of the most serious because it can limit our liberties. Those are the cases I invite this court to look at. And those are the cases on the basis of which the issues I have raised, my lord and my ladies, is that you will find that when you read some of the things I have not read in the spy tapes and the violations that I put before you, when you look at whether or not, even if Mr. Zuma may have contributed to some delay by going to court, because we told that even approaching a court by him is a delay, doing the right thing, not discussing his case with a politician, going to court, making representations, he's responsible. You will find no occasion in these 5,000 pages before you when the postponement was because of him. Yes, he may have wanted to make representations, but that is an exercise of his right as a litigant where he feels that his rights were violated. Those, if you find against us on all of the issues about the delay, and if you think they must be juxtaposed with everything else, I want to invite you to look at those cases and tell us and make a decision that the violations which are common cause of the supreme law of the land do not constitute exceptional circumstances. I'm inviting this court to write any judgment. I'm not desperate to win this case. I'm desperate to hear how organs of state and myself and everyone must behave between now and the future about the Constitution. I want to hear this court tell me that acting unconstitutionally is not exceptional. Those are the issues we say, even if we are wrong, which we dispute, because the delay, the social stigma. When I say in the head, Mr. Zuma is synonymous with corruption now, it's something we write, as I said. We have to think back to that social stigma, whether we would like it unto ourselves. A social stigma you carry as a family man for being accused. And that stigma, I'm inviting you to look at it in a constitutional democracy as an exceptional occurrence that violates the values that we call supreme.
On that point, can I ask this question, Mr. Sikhakhane? As I understand the argument and the papers, that stigma started way back 2000 or 2003, and it's carrying on. This application does not go into the merits of the case. If we were to grant it, it leaves that stigma standing. When will it ever be cleared? Or will it ever be cleared? Because I think it's on record on several occasions that Mr. Zuma said he wanted to clear his name. So in a balancing act, how will that ever happen?
It's an important question, my lady, and let me deal with it in three parts. Because the question you ask is, why doesn't he go to court? A lot of people think I should just walk Mr. Zuma to Mampuru prison or Westville, because...
No, but that's not my question.
No, I'm saying that's my introduction to the court.
You started it on a wrong footing. You say, why doesn't he just go to court?
Well,
and I don't want it to be misunderstood. I'm
Okay.
saying, how do we balance all of those factors?
You
that
balance it this way. I
Yes.
still ask you to consider that any accused person, whether you may